like to call the meeting to order this afternoon and acknowledge that we are in Treaty 1 territory, the home and traditional lands of the Anishinaabe, Ojibwe, Inuit, Cree, and Dakota peoples, and in the national homeland of the Red River Métis. Our drinking water comes from Shoal Lake 40 First Nation in Treaty 3 territory. My name is Brent McIntyre, and I'll be chairing the hearing today. To my left is Ian Mann, and to his left is Michelle Duncan. Our assessor for today is Jennifer Martins, and our recording secretary is Belhan Rojo. We will be hearing applications for revision of the assessment roll in accordance with the Municipal Assessment Act. The matters for which revision is requested have been described in each application, and we will limit discussion to those matters. The statements that are made at this hearing are sworn testimony, and anyone speaking to the matters must be sworn in. Be advised that comparisons of assessments of properties are not considered evidence of market value by the Board of Revision. The Board of Revision is appointed annually by Council and is independent of it and the City Administration. It makes its decisions on the basis of the evidence provided at this hearing and issues a written order that will be mailed to all parties as soon as possible. Please note that the Board's decisions with respect to an application may be appealed to the Manitoba Municipal Board if the matter pertains to assessed value or classification, or to the Court of King's Bench if the matter pertains to the application of exemptions from taxation. Should you wish to appeal, information on how to do so will be included with the Board's order. With respect to the hearing process, I will confirm the points of appeal with your property to be addressed with each applicant following the swearing in. We will then have the assessor's testimony followed by questions that the applicant may have, and then the applicant's testimony followed by questions. Each side will have an opportunity to summarize if they wish. Once all the evidence about an application has been brought forward, the applicant may leave. The process will repeat for each item on the docket today. The session will close after all the applications have been heard, and the Board will deliberate in private and make its decisions. You will receive the Board's decision by registered mail as soon as possible. As information, all public hearings are live streamed, recorded, and will be part of the public record. We will be hearing items 1, 4, and 8 on our docket today. Ms. Rojo, please affirm the assessors and the applicant's testimony. Thank you very much.
Madam Assessor, please state your full name.
Jennifer Suzanne Martins.
And you affirm the evidence you're about to present is the truth, the whole truth, and nothing but the truth?
I do so affirm.
Thank you. Mr. Neufeld, please state your full name.
Ayrton Neufeld.
And you affirm the evidence you're about to present is the truth, the whole truth, and nothing but the truth?
I do. Sorry, I had audio trouble earlier. I am just sitting in for Rocky for this penalty. He should be showing up in the next short while.
Okay,
we just have 2 properties here.
Mr. Mercury, please state your full name.
James Mercury.
And you affirm the evidence you're about to present is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you very much. The first item on the docket today is 3 Reindeers Drive, and I understand there's a preliminary issue on this one.
Yes, there is. Sorry, did you want me to read in the roll number and the file number? And then
I was just going to mention that.
Yeah, okay. This is file number 22-3055. Roll number 0400381100. And on this one, I would like to request the burden of proof be placed on the applicant for non-cooperation, section 53(3)B of the MAA. And if reduction in assessment is ordered, that it follows section 54(3.2) of the Municipal Assessment Act.
And you may proceed with your information as far as the non-co-op request is concerned.
Okay. If we look on page 8 and 9, we have the information here from Canada Post regarding the delivery. And on page 10 through 14, we have a copy of the income and expense mailer that was sent. Thank you.
Thank you. And Mr. Mercury, do you have any questions of the assessor?
I do. Just looking at the brief that's been submitted, and you've produced a copy of the mailer which I believe is starting at page 10. Do you see that?
Yes,
Okay. So this would have been sent out to an address in British Columbia. Is that correct?
yes.
Okay. And it wasn't addressed to anyone's attention in particular. Are you able to identify anyone on this document, anyone in particular?
No.
Okay. And when we look at the delivery documents, if you look at page 8 and page 9, page 8, there's a reference to a delivery date of June the 16th, 2021. And you'll see under signatory name that there is no signature noted. It says signature unavailable or not requested. And then similarly at the next page, there's no reference to anyone in particular having received this document. Typically, my understanding, Ms. Martins, is that the city will look for a signature before requesting a deferral. Are you aware of that?
That was the case before COVID, but due to the change in Canada Post procedures over the COVID period with social distancing, that has changed because Canada Post wasn't asking for signatures. So it's really difficult for us to insist on signatures when that wasn't Canada Post procedure.
Okay, so, but the practice of the city of requesting signatures really was a matter of due diligence to make sure, in fairness to the taxpayer, that they actually received it, or someone with authority to receive the document actually received the mail, correct?
Actually, it's my understanding that once the city has mailed out the first mailer, it is considered to be received after 3 days. And the fact that we send out a second mailer that is tracked and requesting signatures is going over and above.
Okay, so when you say it's your understanding that it's considered to be received after 3 days, what are you relying on?
Just our procedures. We consider it to be received, and once and we send a secondary one if we have not received any information back out of courtesy and in an attempt to do what we can to be considerate of the taxpayer and allow them a secondary opportunity to give us the information.
So are you aware of any of the municipal board orders that have dealt specifically with this issue, namely, or that have specifically indicated that simply mailing a document is not sufficient? Are you aware of that?
No.
All right, fair enough. And again, fair to say that without evidence of a signature or identifying anybody in particular on these documents, you wouldn't know whether the person or whoever may have received this document actually had authority to accept it, or whether they actually brought it to the attention of the owner?
I would say that the expectations from before COVID are not the same as they are for the expectations during COVID, when the procedures of Canada Post were changed. But as to that, no, I similar to any time we send out the mail, we aren't aware of who receives it. We do have the same mailing address and information on the envelope as we did have for the assessment notice prompted this appeal. So I would assume that it would go to the same person.
Okay. Did you look into these mailings would have been sent out during COVID, as you mentioned, and there would have been restrictions in place. Many workplaces, in fact, would have been closed during this time. That would have been in the summer of 2021, correct?
Yes.
Okay. Did you investigate whether the business in question here was in fact open at the time that this was sent?
No, I didn't.
Or you didn't? Okay. Those are the only questions I had, Mr. Chair.
Thank you. And Michelle, do you have any questions?
No questions at this time.
And Ian?
No, I don't have any questions. Thank you.
And I have no questions, so we'll take a 5-minute recess.
Yes, if I can have an opportunity to present our submission before you do.
I didn't realize you had a submission.
Yes, we have some rebuttal documents that were provided to the board.
We don't have them.
They have been distributed.
Oh, we just got them now.
They're listed under item 1.
Item 1, I've got 4.
Item 1 docket.
No, item 1 for 3 Rangers Drive. There are 3 rebuttal documents.
Oh, I see where they're.
Okay, right underneath the applicant's screen. Okay.
Does everybody have those?
Yes, we have them now.
Okay, thank you. So just in response to the city's submission here, it's clear that sending a document by mail is at least at this time in 2021 is not deemed receipt. That may have been the assessor's policy. In fact, that's not consistent with my understanding of the deferral requests. In many of the past cases that I have had, they actually do look for proof of receipt. This has been dealt with by the municipal board on numerous occasions, Mr. Chairman, and we provided the Mo Investments case, which is a municipal board decision. Hopefully you have it. I'm not going to go through the entire decision, but it was a deferral penalty case. In this particular instance, the city had sent a I&E mailer to the property owner at 946 Corden Avenue. It was actually picked up and received by the tenant in this case, so it had been delivered to the site, but the evidence was that there was no evidence that the tenant had actually delivered the document to the owner, and therefore, at the end of the day, because the city was not able to prove receipt by the owner or someone with authority to receive the document, the deferral penalty was denied by the municipal board. And I simply wanted to bring your attention to a couple of highlighted paragraphs in this board order at page 9 of the order, which is highlighted in purple. You'll see that the board has satisfied the assessor requested information from the owner by sending the 2011 and 2012 first and second request to the address for service by regular and certified mail. As to whether the evidence proves the owner received such requests, Litcherson has settled that although proof of service of a request for information does not require an acknowledgement of receipt card, the assessors must still establish that the request found its way to the owner. And then if you scroll down to the top of page 10, it indicates that if there's uncertainty whether a request was sent to the right party or to the correct address, or that it was duly received by the owner, the assessor may wish to decide not to raise a possible failure to comply. And so what this order holds clearly is that simply by sending it in the mail, that is not sufficient evidence of service. And if necessary, I could provide you with additional municipal board orders to that effect. So if we come back to the evidence that's presented by the assessor, just simply sending it to the address and having Canada Post note that it's been delivered does not satisfy the burden of proof under the Municipal Assessment Act, clearly. And that's why we require more in terms of proof of service. The fact that there may be difficulties due to Canada Post policies during COVID, I would suggest does not operate to relieve the assessor of his obligations to actually serve these documents. In fact, an additional document we provided as part of the rebuttal just speaks to the when the COVID restrictions started to be loosened in BC, because this was sent to a BC address, and there's a document titled COVID recovery at the top, and you'll see that.
Just
you have that.
Oh, it's not the second one?
It's called 3 Reindeers BC closure dates.
Yeah, I see it.
Okay.
Michelle, have you got it?
Yeah.
Okay, proceed.
Yeah, and all this really is designed to show is that their COVID restart plan was, effective July the 1st of 2021 when it was, a phased restart plan to start. So at the time, the first mailers would have been sent. There would have been, widespread restricted access to various facilities in BC. I think all of us will have an understanding of the restrictions generally that were in place, not only in Manitoba, but elsewhere in and around that time. The final set of documents that I wanted to just highlight for you is just some recent board orders from the Board of Revision. They're called, the document is titled Penalty Cases, if you have that available. The only reason I bring these to the attention of the board is that essentially there were very, very similar circumstances in all of these cases where penalty requests were made by the assessment department. And Mr. Neufeld had identified the fact that these mailers were sent out during COVID restriction period of time. There was inconclusive evidence as to who actually received the mailers. And so I won't go through all of them, but there's, I think, approximately 4 different board, 1, 2, 3, 4, 5, actually 6 different board orders here, all which would have been very analogous to the case that we were dealing with here. And you can see, and we've highlighted that in each and every instance, the Board of Revision denied the request for penalties. So in summary, Mr. Chairman, our position here is that the evidence that the assessor has brought forward is clearly does not satisfy the burden under the Act. It's not consistent with the municipal board's decision in Mo Investments, and it's also not consistent with a series of Board of Revision orders just recently. And I would suggest that the board should be have top of mind in terms of consistency in terms of how these matters are addressed. So unless you have any questions, or if the assessor has any questions, or if the panel has any questions, that really would be my submission.
And you realize we're not bound by any previous board orders?
I understand that you're not bound by any prior board orders. However, there is, I would suggest, an obligation to ensure consistency. And if there is a departure from a different practice that is being employed by the board, there is a requirement to explain why the board is departing from that practice. So that would be my submission.
Okay, Jennifer, any questions?
Yes. The municipal decision that you brought during that time, was it the practice of Canada Post to get signatures, or was it their practice to not require that due to social distancing?
This was a pre-COVID case, so the issue there wasn't necessarily the signature. The document had actually been, there was evidence that somebody at the site had actually received it. It was the tenant who so there was clear evidence of receipt by an occupier of the premises, but it did not make its way. There was no evidence that it made its way to the actual registered owner of the property who had the right of appeal. And so, the evidence in that case, I would suggest, was actually much better, far better than what it is in this case. And notwithstanding that, the municipal board declined to order it. To answer your question, the answer, it really didn't arise. This was a pre-COVID decision.
Okay. Now, in regard to the Board of Revision orders, do you recognize that even though I didn't bring evidence of it, there's a similar number of, I could bring a whole pack of decisions that accepted the request for application, but
So
okay.
what I would say to that is I can't speak to who actually was present at those hearings and who actually made submissions. Sometimes owners are afforded the opportunity to obtain legal advice, and sometimes they are not. In this case, Colliers did reach out to me to review this matter, and I've dealt with countless number of these cases, and both before the municipal board, this board, and the courts. So what I had attempted to do was to highlight kind of the current state of the law as I understand it. And I know Mr. Neufeld in those prior, I wasn't involved directly in those prior cases, but was aware of them. And I understand Mr. Neufeld brought that relevant background to the attention of the board. So yes, we're not here to necessarily relitigate old cases, but it all depends on the information that's presented to the panel and that's made available to it.
Now, in regards to your other paper here, the COVID recovery, so as of July 1st, they were able to start their plan to reopen. And it says here that 460 days of emergency, being in a state of emergency. Is it safe to say that they would have gotten mail at some point during that time? Or is it your suggestion that the mail that arrived when they were in a state of emergency, that we should just assume that didn't arrive at all?
No, what I'm saying is that this shows what the actual state on the ground is really across the board in BC, and that when we are looking for a deferral penalty, that's a significant penalty on any taxpayer, and that the assessment department has to be very diligent about ensuring that mailings get to the party involved, the taxpayer involved, and there's, in this particular instance, I would suggest there's unfortunately, an extra burden on the assessor to make sure that happens because of not only the Canada Post policies, but the fact that there's a very good likelihood that the person who would ordinarily receive this actually gets it. In terms of whether they actually get their mail at some point, I can't speak to that. I'm assuming that eventually they get their mail, but the Act speaks to the date of receipt, and receipt by a person with authority. So again, to go back to the Mo Investments case, it clearly states that the act of actually putting it in the mail does not prove receipt. So, something more is required than what's been put forward here.
What is your expectation that we should be doing in order to guarantee that it has been received by the appropriate authority figure?
Well, again, I came out here to speak to policy. That's ultimately for the city of Winnipeg to do. But, we deal with legal process and service all of the time. For example, down at the courthouse, and if you want to issue a claim, whether it be a small claim or a statement of claim, the obligation to prove service is on the party who issued the claim or makes the request. And so you have to provide an affidavit of service to show that you've actually sent it to someone. This person has authority to accept it. There are corporate records that are available in terms of a company search that could be done in terms of who is the attorney for service in either in Manitoba or in British Columbia. If this company is carrying on business in Manitoba, there's a requirement that they have a registered office in Manitoba, and if they have a registered office in Manitoba, that they are required to have an attorney for service. In many cases, that's a lawyer. I personally am attorney for service for a number of companies. So when a claim is issued, for example, on a BC or an Ontario company, and they want to serve it, they don't just fire it off in the mail and hope that they get it. And nor would any court ever accept that type of proof of service. What they typically do is send the document to the registered address, send it with a process server or someone who can confirm receipt of either the attorney for service or someone in care and control of the business. Another option for the assessment department is to send it directly to the business itself, the controller, if there is an office, a local office, somebody who would likely be dealing with the property assessments and the operation of the actual business. So it depends on the circumstance at play, but there's a variety of different options that are available. In terms of suggestions, I can offer that, and I'm not sure I'm here to offer policy for the city, but all I can comment on what has been provided for the board in this particular case.
Thank you.
Was that all your questions?
Yes, thank you.
Okay, Michelle, do you have any questions of either Mr. Mercury or Ms. Martins?
Ms. Martins, was there a history of non-co-op prior to 2019?
I'm not sure.
That's the only question. Thank you.
Ian, any questions?
Yes, with respect, Mr. Mercury, with respect to the Mo Investments ruling, I'm just having a chance to review it. You indicated that there was no evidence to show that it was received by the owner. I'm looking at page 7, and it appears as though looking at the second paragraph from the bottom of that page, it appears, in fact, that there was positive evidence that such a document or such a request was not received. I'm looking here. The evidence is clear that neither the 2011 first nor second request were received by the owner through Mr. Zaid.
Yeah, so it came to the tenant. Sorry, I just have to go back to this. There was Mr. Zaid, I believe, was the tenant. Mr.
And Mr. Zhao.
Mr. Zhou was the, I get these names confused, was the tenant, and it did not come to the attention of the landlord, Mr. Zaid.
And there was evidence to that effect. It wasn't just a case of the city relying on delivery or the mailer. That would be the reasoning.
So the point there is that there's no question. Let's just put it another way. Imagine that this had the Mo case. They had sent it in the registered mail, and somebody had signed for it. It was Mr. Zhou, for example. Well, if what the assessor is saying today is correct, then that would have been case closed. Somebody picked up the mail, signed for it, and the penalty would be granted. What the municipal board is saying is that you can't just rely on anybody either signing for the mail or receiving and opening an envelope. That's not the end of the inquiry. The point of Mo Investments is that you have to show that somebody with authority actually comes to their attention. It could be the owner, or it could be somebody like a property manager, for example, who is expressly authorized to receive these types of documents. And in Mo Investments, and I could send you various other cases, unless there's evidence that that person who receives the mail either signs for it or physically acknowledges receiving it, unless there is evidence they have authority, the case law is very clear that is not sufficient evidence of service.
And turning to page 9, in your highlighted portion, that's you've addressed that. But I'm looking at the last sentence: how the assessor establishes such receipt by the owner is not important. Presumably,
that's right.
Presumably that can include by inference that there was receipt, or the municipal board appears to leave open the ways in which that kind of service can be established.
Right. So the meaning it doesn't have to be by registered mail. It could be by personal delivery, or it could be by a courier giving evidence that this was actually sent. But I have not seen any case reported where you just simply draw an inference. I had another municipal board case just recently. I could provide it to the board if you wish, where the provincial municipal assessor basically took that same position, saying, we sent this in the mail. We clearly sent it in the mail. This was for a property in Russell, Manitoba, a hotel. And they said, we sent it. We've sent hundreds of these documents. They pay their taxes. Surely they must be getting the mail. You must draw an inference that they received it. And the board said quite clearly again that you cannot draw that type of inference, particularly with respect to this type of document, as important as this is. Essentially what happens is if you grant a deferral order, you're stripping a taxpayer of their right of appeal for 1 year. There cannot possibly be a more dramatic penalty that you can impose. And so in light of that, I would suggest the consistent theme that I've seen from the municipal board anyway, is that there's a higher onus with respect to these types of documents when you're serving these types of documents. Now, what I can tell you is that in 2022, a year after this, the series of cases have been decided, that for mailers sent out in 2022 and afterwards, Ms. Martins is correct. The legislation actually was amended to say that there is deemed receipt for mailings sent after 3 days. And that's how the legislature has dealt with it in the Municipal Assessment Act. But that amendment was not made until 2022. These mailers were sent in 2021. And the law as of that date was that you cannot simply infer or have deemed receipt of service. It's just, that's contrary to the state of the law. So specifically, the Municipal Assessment Act, I can find it, the reference for you, is the new section 64.1 sub 1. There is a deemed service of any document, which it's somewhat of a unique provision. I've never seen anything quite like it, but the legislature has amended the act to say that there's deemed service, but the amendment date, you'll note, is 2022. So legislation is not retroactive in effect. It's prospective only. That's a firmly entrenched principle of law, and that the date of these mailers was in 2021. So you cannot infer service, you can't deem service, you must prove service. In this case, the assessor clearly hasn't proven service.
Thank you. I have nothing further.
I just have one question, Jennifer. Was there a second mailing sent to this owner?
This was the second mailing.
This was the second mailing. So there was no response from the first one?
Correct.
Okay, thank you very much. The board will take a 5 to 10 minute recess and deliberate this matter and come back with our decision. Thank you very much. We'll reconvene the hearing this afternoon. The panel has deliberated and the assessor requests that the burden of proof be placed on the applicant for non-cooperation under section 53(3)(b) of the MAA is denied. So we will proceed with the hearing. Jennifer? Now, Mr. Mercury, are you staying for the whole hearing or?
I expect I'll likely depart at this stage, although I understand we might be waiting for Rocky to return. Is that right, Ayrton?
That was my understanding. I'm just trying to find him. Just give me a minute. He wasn't here.
Did you want to proceed to the next item while we wait?
Is Ayrton dealing with all of them?
I don't know.
Yeah.
Ayrton, are you dealing with all of the properties? Or?
Oh wait,
I
looks
yeah,
like
I think
it's connected now.
joining. I did all the 15 ones, so you thank me, but you can
You missed a couple.
yeah. Maybe next time.
Oh, he's there.
All right, with that, I'm going to sign off now that Mr. Neufeld is here.
Okay, thank you
Thank
very
you.
much. So Rocky, are you presenting or?
Yeah, I think so, yes.
Okay, you want to swear in Mr. Neufeld?
Okay. Mr. Neufeld, please state your full name.
Rocky Neufeld.
And you affirm the evidence you about to present is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Thank you. Jennifer, you may proceed with your brief.
Okay. So for roll year 2023, the assessed value is 16,974,000. This is a neighborhood shop.
Sorry, I don't mean to interrupt. Can you give me the file number? All your briefs are listed by file number.
Sorry, this is file number 22-3055. Got it. Okay. This property we have listed as having 3 buildings with 15 premises, 1 story. We have the year built as 1998, and the wall height is 15 to 23 feet. We have a land area on this of 238,980 square feet and a plan area of 65,676 square feet. On page 4, we have an income workup. For the 68,892 square feet, we have a potential rent of $1,277,008. We have applied a vacancy loss of 5%, expenses at 3% with a shortfall at $9, giving us a net operating income of $1,145,000 and $1,145,762. We've applied a capitalization rate of 6.75, giving us the $16,974,000. On the last page of my brief, there are some pictures. It shows an overhead view, and then it shows a street view. It's a larger property. It's tough to get them all of the buildings on a street view. That's everything for me. Thank you.
Thank you very much. Mr. Neufeld, any questions? Rocky?
Yeah, no, sorry, you're just buried under my paperwork here. You can still get buried on a computer screen with all these open screens. Page 4. This is the valuation. Was this all done by the model?
Yes, it was.
And did you have an opportunity to compare that against previous year's statements? I know you're saying you didn't get this one. You did have some history on this, though, didn't you?
I didn't get a chance to review previous years on this.
Okay. Sorry, I was napping there. Okay. The comparables that you've listed here on your pages, page 2, I take it, is the subject leases. These are your workups?
No, the page 2 is the subject leases that we had on file previously.
For this one, right?
Yeah.
And then comparables on page 3.
Yeah.
Okay. Sorry, just one sec. And your workup. There are no. I mean, what are allowed for non-recoverables are 3% then?
Yes. We have the 3%.
And in terms of the capitalization rate table, page 6, what row does this fit in?
I would say this is within the power center / neighborhood row.
Power center neighborhood?
Power center / neighborhood, because this is a neighborhood shopping center.
Oh, okay, so that's the coding on. So we had to find that. Oh, page 4 NSC, and that compares to NSC here. Now, a power center would be deemed to have a certain amount of
This isn't deemed a power center.
it's not a power.
This is not a power center. It's not considered a power center. It's considered a neighborhood. They put the two
Okay.
together, but this isn't considered.
So what is the description of a neighborhood shopping center? And I really don't know because I don't get this myself.
Hang on one second. I have the actual description in one of my folders.
I'm not asking this because I'm looking for anything. I really don't know what they are.
Okay. Okay, a neighborhood shopping center is a shopping center usually over 4 tenants. And we have some examples of comparable ones. We have Lindenwood Markets, McLeod Mall, Tuxedo Junction, Hastings Plaza, Randier Square, which is this one. I think that's this one, is it not? Cavalier Square, etc. So, and these are ones that we can look at to compare whether a property that we're looking at should be considered a neighborhood shopping center. Is that helpful?
Yeah. Okay. And so are they supposed to have an anchor?
No.
Okay. So this one though has an anchor in the Sobeys,
Yeah.
correct?
Yeah.
And on your page 4, the model puts that rent at $17.99. And did you take a look at the actual rent for Sobeys? I mean, considering it's such a large part of the value, I'm wondering if you knew that it was actually $2 less at 16. That might have made a small difference in the overall value.
No, because we don't have that this year because we don't have the current funds because we did not receive the mailer information for this.
You do have it in your records from 2019, don't you?
Is it in there?
I mean, I have it. I'm just wondering if you didn't have that one as well. Was that one also under debate for not being sent?
Oh, I don't have it here. I don't have
Okay.
it's not in my brief.
All right. Oh, well, that's fair. And was this sort of mall impacted much by COVID? Have you seen a lot of losses in properties like this?
These ones were less impacted than the closed malls. Anything that had a grocery store as an anchor tenant was less impacted than properties where all of the all of the tenants had heavier restrictions. Things that had anchor tenants that were grocery stores and liquor stores did better than ones that did not have grocery stores and liquor stores.
Right.
So these ones were more available for curbside pickup and things. Does that answer your question?
Yeah, no, it's sort of like what we all saw is that grocery stores did all right, liquor stores did all right, but then a lot of small operations were impacted then.
And that's why we asked for the level of impact in the mailers so that we would be able to look at them in a fair manner. But we didn't get that information.
Okay. Sorry, those were my questions.
Thank you. Michelle, any questions?
No questions at this time.
Ian?
I do, Ms. Martins, just with respect to your workup on page 4, I'm trying to reconcile some of the leasable area and the square footage. Focusing on the restaurants, the standard restaurant at 1,379 square feet and immediately below it 6,336 square feet. But I see in the actuals, there's 14,000 square feet leased by Famous Dave's. Where would that appear in the workup? On page 4, the 14,000 block square feet for the restaurant.
I'm off the top of my head, I am not sure. We have okay, for Famous Dave's, we have them occupying the 6,336 square feet.
Okay, then how does that reconcile with the subject property leases, or is one of them just a typo?
Well, it's not the current, so I'm not sure if they've gone down in space since 2017 and that we have the actual, or if they are occupying more space than we have them licensed in for.
Okay, thank you.
And I have no questions. Thank you. Rocky, you can proceed with your presentation.
Thanks. So I was just following up. I'm not following up. I just was trying to follow that issue here on. I couldn't find the Famous Dave's on the top end either, but I see it the 6336 there. Okay. We have a small difference in income from the assessor, and essentially their numbers on the small sites were up and down, and they almost matched the subject in total, not in the actual experience, not in site by site. But the big difference was the Sobeys. The rent is $16, and the model had it at $18 almost. So that's what you'll find is our major difference. It's the $2 on the 36,000 square feet. On the income side, that was the major one. But like I said, there were ups and downs. We did use the actual rent roll, and so the model was $1,277, and the actual was $1,233. In keeping with our sticking to real life experiences, we used an actual vacancy of 3.45, and the model was at 5. We used actual non-recoverables at 5% and 2%. I'm going to guess that those numbers are just about a wash when we all of our expenses. Just quickly adding the difference. Well, what do you know? Yeah. So we're actually, when you take in all those numbers, it's $6,000 apart on our expense side. So there's nothing to choose from there in terms of, it's just the way we structured our statement was different from the assessors. And we followed the actual money. So the major difference is the income period. And the rest of the numbers are, if you add up, you know what I'm saying is the vacancy, the non-recoverables, the structural, the shortfall were almost the same as what the assessor had, unless I calculated that wrong. Our capitalization rate is 7.25, and when we went to look at this, we went to the Collier's cap rate, and as I was repeating 100 times a day almost, our cap rates are skewed heavily towards looking at the yields required and the mortgage rates. They do have retail sales in them, but in Winnipeg, for the time period immediately preceding April 21, there were so few sales. There was nothing. There were no cap rate sales. So we do look at national sales. We do look at yields, and our people in investment services worked out these numbers. And so this being probably grocery community or neighborhood strip, it's the same number for the best product between 6 and 6.75. I'm reading on page 33, and our definitions are listed here. And it would most resemble a neighborhood or strip center anchored by smaller supermarkets and with a mix of smaller attached retailers. And that's the best product range. And then from there, we look at the deficiencies of the subject, and deficiencies we noted are back on page 2. And firstly, it's the way we calculate our cap rates, which is based on the purchaser's cap rate, not the vendor's cap rate. So the vendor's cap rate is the one that's used for valuation and for appraisal and assessment. The purchasers is the one used for the investment. So there's a change there. We rated that 3 points, and the difference is about 0.18 of a percentage point on the cap. So that in and by itself means that our premium rate, our prime rate, is 6.18%. The location is not the best. We're all familiar with the neighborhood, I think. It was the corner of Lajimode and Nairn, where the intersections went in, and it was this piece of land that got developed. Fairly poor on access, mainly because that intersection is so busy. It's very difficult to make it through. It's one of those neighborhood things that if you live around there and you know that the routes, you can get in there, and if you don't, it's not good. So it's bad for impulse purchase, bad for impulse retail, and the same goes for the access. These are minor points, all of these. The location, access, each by themselves is about 1/10 of 1 percentage point. Configuration is it's an old style. The newer style developments like this are different. They're more. Imagine what new developments are like would be in Waverly West, where they designed town center. That's the designer's favorite right now. It's more like a neighborhood, back streets, front streets, walking to and from the shops. This is like a strip with a big parking lot in the middle. So there are changes in designs of these shopping centers that have gone over the years, and where I wouldn't even know if one's better than the other, but investors prefer the newer style, and that's a bit of a downside. Again, minor issues. It is not new, so there are some issues relating to maintaining the age and keeping it up to date, in terms of the income growth potential, the two issues there are that it's one major issue. One issue really, all one has to do is look at the rent roll and see who's in there. You're not attracting AAA tenant. So Sobeys would be a AAA, and that's why I was focusing on Sobeys. That's it. The rest of these are franchises or smaller local businesses. So their investment potential. This is the sort of company that rents in these strips, not deemed to be good quality, and it's not because of who they are. It's because this is what is attracted to these sites. The better, the higher grade the higher grade retailer is going to be in a higher grade mall. That's as simple as that. And it's the physical parts of it that have that ability to attract that AAA international or national branded tenant. And as I said, all of these are either franchises or small businesses in the rest of the building. And that's why we had it at 7.25. And that's our presentation. Thanks.
Thank you very much. Jennifer, any questions?
No, thank you.
Thank you. And Michelle?
No questions, thank you.
And Ian?
No, I don't have any questions. Thank you.
I have a question, more or less a redirect to Jennifer. The rent roll is showing a total area of 65,713. Yet in your documents, you're showing leasable as 68,892.
Yes, our area is 68,892.
Any reason for such a discrepancy? And you probably can't answer it, but
Well, we don't, I mean, I'm not sure what it said in the previous, because I didn't attach old income and expense mailers, but I don't have the current income and expense mailer to look at.
okay, thank you very much. That was my only question. And that concludes this property. The next one on the docket is 1919 Henderson Highway. Any preliminary issues, either party with this property?
No.
Rocky?
No.
Hey, Jennifer, you may proceed.
This is file number 22-3298. This is 1919 Henderson Highway. For the roll year 2023, the assessed value is $3,300,000. This is a neighborhood shopping center. We have one building with 5 premises, and there are 2 stories. The year built is 1987 with a wall height of 13 feet. The land area on this one is 45,536 square feet and a plan area of 12,436 square feet. We have the workup on page 4 showing the leasable area of 14,332 square feet with potential rent of $244,004. We've applied a 4% vacancy loss with 3% expenses and a $9 per square foot shortfall, giving us a net operating income of $222,057. To that, we've applied a 6.55% capitalization rate, giving us our $3,390,000. If we go to page 11, we can see some pictures on this one. The top is just a street view. The middle is an overhead view showing the parking lot and the location of the building on the property. And the bottom is a map showing the location on Henderson High. Thank you.
Thank you very, very much. Rocky, any questions?
Yes, thank you. Just confirming then that page 4, your workup, this was all driven by the model?
Yes, it was.
And what sort of land to building ratio would you usually hope to see in a retail operation?
It depends. It depends a lot. This is 3.66, and it depends on where the building is on the property and if there's a good shape to the property. If you look on page 11, in the middle there, with the building placed back from Henderson and off to the corner, it does look as though there is a good sized parking lot on this one. So I'm not sure what the comparison would be for some of the other ones, but I think 3.66 is a reasonable land to plan ratio on this one.
Sorry, but you're saying plan ratio, but that's not rentable ratio, correct? People on the second floor still have to park their cars somewhere, right?
Yes. I think with 5 premises, and if you look at the parking spots, just a rough estimate.
It's 3.18 with the upper level, is it not?
That's still well within the usual.
Oh, are you familiar with the parking bylaw? I'm not the parking requirements in our city bylaw.
I don't know them off by heart, but I am familiar with that they're there. I don't know what offhand.
Well, for example, a retail class 20, 1 stall for every 250 square feet of floor area. Restaurant, class 22, 1 stall for every 100 square feet of floor area. And I'm wondering if you had a chance to do a rough calculation on that basis. The Smitty's, 6,000 square feet, so they need 61 stalls, and 8280 divided by 250 is another 34 stalls. So 95 stalls approximately by our planning bylaw. Roughly, what do you see on your page 11? Do you think they're close to 95 stalls? I'm guessing around 80.
I would guess around 80.
No, I'm bringing this up because this is the most common complaint we have on this mall is the lack of parking. Does this go into the model at all when you have a restaurant in a mall and a fairly tight space allocation?
I'm not sure if they take the amount of parking. The land plan ratio is taken into consideration, but I'm not sure if they have taken the parking bylaw into consideration.
Okay. Well, just in practical sense, do they take the parking requirements? If you have a restaurant and your model has a restaurant in it, does it then look at the plan area and say, "Oh, I think we're kind of tight," or does it think that hard?
I'm not sure if it does or if it does not, because you also have to factor in where the building is on the property, because sometimes the configuration does also affect the amount of parking. So I'm really not sure.
Okay, and your rent in this case, you did have the opportunity to look at the statements. I take it, and the rent is. I'm just looking at it, page 9. Potential rent. You're at 244, I think, and at potential around 240.
Yeah, the model is a little bit above the actual.
Okay. But do the statements indicate full recovery?
Sorry,
I'm just looking at the bottom of page 9. Or the middle of page 9, NOI line 235,000, and that says full.
Yeah. Oh, sorry, it's very fuzzy. I didn't pull it up on my computer. I can hardly read it. Can you just?
I can't read it either. It's all fuzzy. 235. The NOI on your page 9, about a third of the way down, there's a line marked NOI, and the actual is 235,000.
Okay.
And there does not appear to be allocation for vacancy.
No.
So there are some semi-gross leases in the mall then, likely.
Yeah.
And as far as the cap on this one, this is a STP now. So that goes into the line strip, right? And your chart shows that they're slightly better than the neighborhood strip.
Yes.
Okay. Any actual sales, investment properties to your knowledge that the city may have had to rely on?
I'm not sure which properties were used for the cap rate study.
Yeah, okay. No, isn't this, when I look at this though, and I'm looking on page 2, and this is a retail classification, but the only retail to me appears to be Smitty's restaurant. There's a dentist, realtor's office, chiropractic office, and I don't know what XX management is. I'm imagine another office. Is this more office than retail?
We do have a fair number of like medical and office uses in retail property. And it could arguably be used as a property, but this does fall within what we use for what appropriate uses.
It's frozen on our end because our bandwidth probably dropped.
So they're all frozen.
Mm-hmm.
We have a problem?
You can ask them to repeat.
Rocky, can you hear me?
Yeah, fine. No, you can't hear me?
I can hear you.
Oh, I can hear you.
Rocky, they're all frozen.
Well, they can't hear us.
Jennifer?
Let's carry on without them.
Rocky's moving.
Good.
She's laughing.
Oh, they heard me laughing. That's good.
Okay.
Yeah. It's dropping. So we're going to need you to repeat whatever it is that you guys said in the last 3 minutes.
Well, I was asking about that wasn't this, aside from the restaurant, all the other users, they were all office, and shouldn't they have looked at some of the office standards?
And I find that there's a lot of purpose of properties that are retail that have these uses in them. So it stays within a strip mall as I'm concerned.
You're going to have to repeat that, Jennifer.
This property has a lot of the properties that we deal with that are retail properties have a lot of these uses in them. So I don't feel that it should be switched over to an office property.
We get sign in again. Bella?
It's not them, it's our room.
It's our room.
It's our room.
That's because you have 3 people in it today. You're too many in the room.
How do we fix it?
We can take a recess, give it 10 minutes.
Okay, we're going to take a 10-minute recess because of technical issues. Thank you very much. We'll reconvene the hearing for 1919 Henderson Highway. And Rocky, you were continuing with a line of questioning?
Yes, I was. I think I know where to pick it back up. Okay. I was asking about the fact that the tenants, with the exception of the restaurant, were all office, and whether or not this should not be considered more of an office property than a retail.
while the purpose of some of these is office, they are also frequently doing these activities in retail type buildings. So if it was requested to switch from office to retail, or sorry, from retail to office property, you could do that. But this isn't the form to do that. But there are many properties that do overlap and have similar uses between the two.
No, and of course it's not the form, but do the units, with the exception of the restaurant, have rear loading?
I'm assuming the second floor ones do not.
Okay, and of course that's I'm looking at a picture on Google Earth, so I know they don't. But and I'm wondering if that wouldn't be a hindrance to an alternate use of retail.
It might be.
Those are my questions. Thanks.
Michelle, any questions?
No questions, thank you.
Ian?
No questions. Thank you.
And I have no questions. So Rocky, you can proceed with your presentation.
Okay. Essentially, what we're looking at here is a problem with the overall design from the beginning of this property, where the concept had been probably a neighborhood strip. And when they had a tenant, the restaurant tenant pretty much strangled the parking, and it's restricted parking. There's no excess street parking. There's not a pad site next door that they can share. It has what it has, and so for the past 10 years, it's been predominantly, or it's actually all been other uses been office. And I'd spoken earlier about the bylaw for parking, and the bylaw for office, of course, is one stall per 750. In some cases, one stall per 1,000. And we're not talking about an issue of compliance. What we're talking about is practical sense. Office just uses less parking. So the site was forced into this sort of arrangement. And it's what it does is it limits the ability of the site to earn. The assessor was 100% correct. You could have office, you could have retail, and if you have that flexibility, you can go to the market and expose your property to twice as many users, and therefore it's called your bid rent potential is much higher. In this case, it is not. It's restrictive, and the income that has been in place for this property for the past decade has been virtually stagnant because it just limits the growth. And that's the issue with that. And so we looked at the prospect of an increase in value in a property that doesn't share the same growth characteristics. That's what we found to be a bit difficult to deal with. The income is, as we said, $235,000. That's the potential. There are some non-recoverables in there, some tenants with some older leases that the owner does have to carry. We put in a market vacancy, and of course non-recoverables, because there are non-recoverables. The structural reserve or shortfall we've calculated at $9.13, and that's again looking for the actuals and being consistent in what we're doing. And sorry, I'm going to get back to the vacancy. Our vacancy, therefore, is a bit higher than one would think of for retail, more office. Now, the office market at the rental end like this is not as strong as the owner-occupant end. During COVID, there was a lot of there were a lot of movement to the suburbs, and where a lot of medical offices even, and where space became available, they preferred to be owners and no more tenants. And if their operation was large enough, they could justify buying. Where the operation is small and you have 1,000 square foot units, you're a taker. You have to take whatever the market has in space, and so this particular one mall is just got catering to lower end, and the alternatives for them would be work out of your basement or have an inexpensive office, and that's the market they're in. That's just what it is. The cap we've selected, was dependent on the income characteristics, because the last property I talked about, where the factors affecting it were different, in that the restrictions were some physical differences, and the quality of retail, which is far riskier. In this case, the property has already settled into its level and is consistent, so the cap can be slightly more competitive. This is not a premium AAA property. This is not a AA. This is not an A. This is not a B. This is D, miscellaneous office suburban with an attached restaurant. And as a result, the rents have been stable and proven to be in place for years. And that was the consolation to the woes on the site, because you could be more competitive. My opinion, 7% is extremely competitive for this type of property. And that's our presentation. The statements are page 3 and 4, and they show the story of the income. And as I said, the last 3-4 years are virtually identical. So my issue with this is I don't see why there was an increase at all, much less one that was over 20%. Thank you.
For any questions?
No questions, thank you.
And Michelle?
No questions.
Ian?
I have a question with respect to the cap rate selection at 7%. This is, I guess, a hybrid property, for want of a better word, between retail at the Smitty's restaurant and the offices. Is that fair to say?
Yeah, that's I guess the way to describe it.
And I'm looking at the cap rate table that you have provided in comparison with the cap rate table the city of Winnipeg has provided in their brief. And I see in the cities that the difference of suburban A or suburban B, 5.6 to 6.9 between the 20th and 80th percentile, whereas the strips would be between 6 and 6.8. If my question is, if this is predominantly office or hybrid, should that affect the cap rate by way of lowering it?
Lowering, no. I think when you start thinking about a hybrid, you go to the lowest common denominator, lowest risk common denominator, which is a high cap, because you have a mix of problems. You don't know which one can impact you. You know, if you have office, you have one set of problems. You got restaurant, you got a different set of problems. If you got two sets of problems attack you at the same time, that's a high cap. But the issue with using these tables is that everything the assessors presented on page 6 is not this product. Everything we presented on our page 31 is not this product. This is of a lower investment interest. And the only reason, as I said, that I even would consider, or we even considered 7%, was the fact that they've managed to be stable at this level for 10 years. Same rent, no growth, but it's a stable investment. Smitty's made it through COVID, unlike a lot of other restaurants. And that was the upside on it. If you shot for $20 rents, you're going to cap this higher because it's a bigger risk to maintain that level. Higher risk, higher vacancies, higher turnovers. So this is actually like a Winnipeg story. The concept here is be full, not focus on how much you make.
Yeah, and these leases, the actuals have been in place since 2013 and 2014, about 2006 for Smitty's, I guess.
Well, there have been renewals along the way. Like the owner is fairly astute in getting the renewals. So these are occupancies that we published on page. The assessor has them. I guess
I was looking on the assessor's page 2.
2. All of these are occupancies, and I was actually, when we're having the break, going back and looking at the 2012. And it's the same group of tenants. They've all been in there longer. So these leases that are in place would be terms and renewals. Like for example, the Smitty's is 22 years. I'm just trying to remember what that was. I have it somewhere. I think it's a 10 and 2 5s for renewal. And most of these others would be a 5 and a 5 renewal.
Okay,
They're not
thank you.
going anywhere. They're and the rents aren't going to change much.
I have nothing further. Thank you.
Thank you. Just a question about parking. Is there not parking on Strood Avenue?
I have my Google Street View on Strood. Let me look. Strood doesn't have curbs. It's got, and there are, I don't believe parking is allowed. It's a narrow, very narrow street with driveways all up and down it. Does not appear to be, oh, there's one car parked on Strood. I'm just looking for signs here. I don't see any. There may be space for some cars on Strood. But again, you know, that's street parking and we're in the suburbs and still got to live with your issues.
Okay, that was my only question. Thank you very much. That concludes this property. And we will go to the last one on the docket, 1111 Monroe Avenue. Any issues with this property, either party?
No.
No? Okay, Jennifer, you can proceed.
This is file number 22-3471, roll number 0205094550. For the 2023 roll year, the assessed value $8,979,000. I do have a recommendation for this one.
Okay.
Looking at this one, I took into consideration the tenants in the old building compared to the tenants in the new building and adjusting the rents using the premise qualities. The new potential rental income would be $553,857.
You're kind of breaking up, so if you can repeat that again.
The new potential rent income would be $553,857.
Okay, that came across clearly.
Leaving the other parameters the same, the new total would be $7,373,000.
And leaving all the parameters the same, the rest of them.
Yes.
And Rocky, are you with us?
Yes, I am. I think Ayrton had accepted this earlier, so we will concur.
Yeah, there was the income is showing is lower in her offer than the actual, so why we were okay with the other parameters. So yes, we are in agreement with that number.
Michelle, any questions?
No questions, thank you.
Ian?
None, thank you.
And I have no questions. So that concludes the hearing today. We have heard all of the items scheduled this afternoon, and this hearing is now adjourned. Thank you very much, everyone.
Thank you.